Our Business from the Bench segment tonight, the Supreme Court has rejected the case of the transgender teen, Gavin Grimm, sending the case back to a lower court for a preliminary decision. This comes after the Trump administration withdrew Obama-era guidance allowing trans students to use the bathroom corresponding to their gender identity rather than their birth gender in public schools. With me now to break all this down, from the Daily Caller News Foundation, legal affairs reporter Kevin Daly. Kevin, good to see you.
Hey Liz, always good to be with you.
All right, Kevin, Supreme Court sent this case back to the appeals court. What exactly does this mean?
So what happened yesterday was the Supreme Court essentially punted on their first major trans rights decision. They were scheduled to hear arguments in this case actually later this month, but the circumstances of the case changed dramatically when the Trump administration issued guidance which rescinded Obama-era regulations which informed public schools that they should allow transgender students to use the bathroom corresponding with their gender identity. That's important for this reason. When a lower federal court, the Fourth Circuit Court of Appeals, heard this case, they determined that the court needed to defer to the Department of Education's interpretation of the federal anti-discrimination law, Title IX, which governs sex discrimination in public education. However, now that that guidance has been rescinded, the core ground on which the Fourth Circuit's decision had rested was in effect removed. So the Supreme Court said procedurally it would be inappropriate for us to hear this case. But I'd also say it's important for a second reason. When the Supreme Court decided to take up this case, they asked the parties to argue two questions. The first was the deference question I just discussed. And the second was, does Title IX, the law I mentioned just a moment ago, require public schools to accommodate transgender students in terms of their bathroom use? They could have still heard this case on that question. However, I think the four liberal justices took the temperature of Justice Anthony Kennedy, who was going to be the swing vote on this case, and determined he probably wasn't ready to go that far and decided to send this case back to the lower court at the risk of an all-out defeat on this issue.
Right, but this is the interesting part, I think. When you're talking about the Fourth Circuit Court here, they did defer to the Obama Department of Education guideline that directed, it wasn't law, but it was directed public schools to let transgender students use the bathroom. But they also said it wasn't just because of that. They also pointed to the Equal Protection Clause and said that it violated Title IX. So it wasn't just the Department of Education guidelines. They were almost, I think, protecting themselves in case those guidelines changed because the guidelines weren't legally binding. So giving it back to the court, is it going to change based off of Trump's directive?
Yeah, you know, that's exactly what happened here. The student who brought the lawsuit against his school, which is refusing to allow him to use the bathroom corresponding to his gender identity, anticipated that this Obama-era guidance could disappear under the Trump administration, so they buttressed their argument with additional arguments, one from the Equal Protection Clause, one from Title IX. Now the Fourth Circuit has to decide if Title IX requires public schools to allow students to use the bathroom corresponding to their gender identity. And the student makes an interesting argument here, and it's an argument that's been endorsed by other federal courts around the country. He says that discrimination against him as a trans person is based off of gender norms and expectations about sex. He says that this is exactly the sort of sex-based discrimination that Title IX protects against. So now the Fourth Circuit has to decide that question, and it's worth noting that other federal courts around the country have endorsed that view. The trouble with this case is it's unlikely it will ever return to the Supreme Court because the student is a high school student. So even if the Fourth Circuit reaches a decision about that question before the end of the school year in June, it's practically impossible for the Supreme Court to reach a decision on this case within that time frame. So in essence, it's unlikely we're going to see a major case on transgender bathrooms at the Supreme Court for years to come.
Right,
so this is a
Kevin,
major victory for people on the social conservative side.
Right, and correct me if I'm wrong here, but it seems to me when it comes to the Title IX application here, which prohibits sex discrimination in schools, it really comes down to the very narrow question, is gender identity considered sex, or is sex just the biological gender that you were born with? And is that a question you expect will reach the Supreme Court at some point? Because it seems almost funny to me. It seems ironic to me that we would be leaving that to a court rather than leaving that to culture.
Yeah, that's a great point. So let me answer that in two respects. In the first place, the Supreme Court is going to have to confront this issue eventually. There are other cases that are percolating in the lower appeals courts that raise this question, so they can't dodge it forever. But you raise a good point that a lot of conservative critics have raised, which is to say, the question of how we should accommodate transgender individuals in terms of bathrooms and public spaces is a question with huge societal implications, and it is not the sort of thing that we should outsource to 9 octogenarian lawyers who don't represent the wide spectrum of public opinion on this issue. This is the sort of thing that we should leave to a democratically elected legislature, to the people's branches to figure out. That was an argument that was raised by conservatives on the Supreme Court during some of the famous gay marriage litigation, and that's an argument that we're seeing again. And so there's an important argument to be made here about judicial humility, about deferring to the will of a Democratic majority on this issue instead of deciding it by fiat.
Right, because it seems like, and this is a repetitive thing, but I think it seems like in our political environment, that's what we're tending to do, is punting these big decisions to the court, to 9 unelected judges, instead of working it out legislatively or sending it back to the states, where in my opinion, that's where social issues belong. Kevin, one last question. This is from the legal aspect here. I think one of the main arguments that are coming from the people representing this transgender teen is that this case parallels the civil rights issues of the 1960s, that denying him the right to use the bathroom is the same as, denying a black person the right to eat in a restaurant or ride the seat in the bus where he or she wants. Legally, from a strictly legal standpoint, is there a parallel argument within this case?
What those individuals will say is, as in the civil rights cases, this is not about where transgender individuals go to the bathroom. Instead, this reflects a deeper public discomfort with transgender individuals, in the same way that, say, whether or not an African American could eat at a certain lunch counter wasn't really about public accommodations. It was about the public's discomfort generally with integration. That, I think, is a potent argument, and as conservatives go forward, it's important that they include compassion and understanding in their messaging, because the civil rights parallels that this draws are potent and they are powerful.
Right, and in the court of public opinion, I mean, that honestly, that type of argument should win, because people should feel that compassion. Kevin, thanks so much for being on the show today. It was great to talk to you.